number 112009, State of Kansas v. Wilson.
Good morning. May it please the court, the state appears by Assistant District Attorney Jody Litvin. And Chief Justice, I would like to request 2 minutes for rebuttal.
2 minutes is granted.
Thank you, Your Honor. The case, the last case here today deals with a motion to dismiss that was granted by the district court regarding the charge for refusing the DUI testing. And that motion to dismiss was granted not based on a violation of the Fourth Amendment, but here we're dealing with a violation of the Fifth Amendment, due process, and the unconstitutional conditions doctrine. And the state took an appeal from the district court's decision here and argues that the district court incorrectly found that the DUI refusal statute was unconstitutional on those three grounds. Here, unlike, I don't know if it were all the other cases in the morning that had previously been discussed, there was a search warrant applied for here and granted after the defendant refused to be tested under the implied consent law. So I believe that was the district court's finding and saying that there was no violation under the Fourth Amendment here because we have a warrant and there was no warrantless seizure here. So I'll begin with the due process argument. And we have a lengthy opinion by the district court, so I was just going to go through it and point out the analysis that the district court did as far as his reasons for finding it unconstitutional and kind of the state's disagreement with that analysis. As far as the due process argument, there doesn't really seem to be a substantive due process analysis here. The district court seems to read State versus Edgar as to give a defendant a constitutional right to refuse testing, which the state's position here is that was not what Edgar stood for. Edgar was focused on the implied consent notices and the improper misstatement of the law that was given by the law enforcement officer in that case. Was the defendant was told that they had no right to refuse the test, which that was a PBT case, and as laid out in the PBT statute, you do have a right to refuse the test, and this court made that clear, but that right is a traffic infraction. So telling the defendant that he did not have a right to refuse the PBT was an incorrect statement based on the statute. However, that did not mean that there is now a constitutional right to refuse testing, which is what the district court held. So we would disagree with that interpretation of Edgar and argue that did not provide a constitutional right now to refuse testing.
But isn't the language in Edgar perhaps dicta about the Fourth Amendment giving the right to revoke consent? And does that come into play?
I didn't read it as such. I read it to be strictly dealing with the PBT statute, the fact that there is language within the statute that allows for a refusal, and that telling someone that they don't have a right to refuse makes their consent involuntary. And I thought that's what the court was focusing on, rather than any Fourth Amendment issue or constitutional right to refuse. I thought this court made it clear that it was laid out by the statute that you could refuse, and telling a defendant that they can't refuse is incorrect and then makes their consent involuntary. If we want to go ahead and do the due process analysis, if we look at strict scrutiny and apply that, even if this court finds that a fundamental right was implicated, this law can be upheld if it serves a compelling state interest and it's narrowly tailored. And I think we hit on this in the first case. The law does serve a compelling state interest to keep the drivers of the public safe on the highways and to keep the uphold the safety and the welfare of the drivers on the road against intoxicated drivers. And then it is narrowly tailored to serve that interest in that it punishes, or the crime, it's a repetitive crime. So even if you refuse the first time and don't have a prior refusal, prior DUI, or prior diversion, you're not subject to the law. So it's narrowly tailored, and you have to have a prior refusal, prior DUI, or a prior diversion. And then it's even narrowed further by you have to be over 18, at least 18 years old, and that must have occurred on July 1, 2001. So we would hold that it would be upheld under the strict scrutiny standard for due process. If we look at the rational basis test, we would also argue that it would apply using the rational basis standard because there is a legitimate state interest and the legislature could rationally conclude that it was served by the statute. Again, legitimate state interest in regulating intoxicated drivers and in protecting the public safety on the roadways. That's all the comments I think I had on the due process issue. Unless there's any further questions, I'll move to the Fifth Amendment issue. And the district court here held again that all of the the law prior to making the test refusal a criminal charge is not applicable now, because that criminal charge, that changes the communication from testimonial and compelled to, from non-testimonial to testimonial. And again, the state's position here is that criminalizing the test refusal statute does not change the nature of the communication that is made from non-testimonial to testimonial. And I think we've had the discussion about it's not compelling someone to incriminate themselves, it's compelling someone to comply with the test that they've already had implied consent to. So it's not making it they're not compelling them to incriminate themselves, they're compelling them to comply with the test. So the district court's determination there that the communication or the act of refusing somehow is transformed from non-testimonial to testimonial is incorrect. And again, just there's longstanding case law that this court has held that the act of refusal is not a testimonial communication. So we would ask this court to continue to find that, even in criminalizing the test refusal. And lastly, for the doctrine of unconstitutional conditions, I hit on that just quickly in my brief. And again, because the district court here found that there was a constitutional right to refuse the testing, we can't condition that you can't deny that constitutional right by limiting it with a privilege to drive or waive that right. However, the state's argument here is that there's not a constitutionally protected right to refuse testing, so the unconditional conditions doctrine doesn't apply. And I think that was really the highlight of what I wanted to hit on, since it's kind of already been hashed out in 3 other cases this morning. We would ask that this court reverse the district court's decision to dismiss count 2 for the test refusal and reverse the decision that the district court made holding the law unconstitutional.
Any questions? Thank you, counsel.
Thank you.
Hey, police court. Kevin Shepard appears on behalf of the FLE, Derek Wilson. And there's been a lot of discussion, and there was a lot of arguments, and there's been a lot of questions by this court have to the other counsel about this issue that I kind of wanted to address to you, but you've made those questions clear. And one of the questions Justice Johnson asked was, can we just criminalize somebody for exercising their right to refuse a search? We know that that's a Fourth Amendment issue. Is if you have a search, it's per se unreasonable unless you have a warrant. If somebody says no, and I don't know why, and I don't want to be rude, but I don't know why the court really even cares whether you could get a warrant or you couldn't get a warrant. That's not the issue. Derek Wilson was being charged for just saying, no, I'm not gonna take the test. That's the issue. Whether they could get a warrant and whether they did get a warrant, which they did, doesn't matter. He is now being prosecuted for just saying no. I'm not going to just give you my sample of my breath. I'm not going to consent to this search. The only way you could make that lawful, knowing that searches are per se unreasonable unless you have a warrant or it falls within one of those exceptions, but just by saying no, the only way you could make it legal is saying you already consented with the implied consent, which goes back to Justice Steagle's questions about whether or not that document means that you consented. Well, Kansas actually answered that question in Edgar. It's not irrevocable. You can withdraw your consent. You can always say, you know what? I know there is an implied consent law, but at this point in time, you're going in for a search, a Fourth Amendment search, and I'm saying no. And because I have that right to do it, and that guarantee, which has been cited also by the Kansas Court of Appeals and the clerk, because I'm exercising that, I can't be punished for that. And that's all Derek Wilson was saying when he wrote it, when that motion was filed for him. Just don't prosecute me for saying no. You went and got your warrant, and I can't be prosecuted for that crime.
If the search were lawful, there was an exception, say we have probable cause with exigent circumstances, then would the refusal have been unconstitutional? The officer asked, but didn't really need to, because they could have just gone forward with the search as an exception to the warrant. Would it be unconstitutional to make that a crime also, akin, as Justice Steagle says, akin to obstruction? Either obstructed legal process by saying no, but we're going to call it a refusal to consent.
Well, starting with we kind of start backwards with the obstruction. The law in Kansas is you have to substantially hinder. I don't think saying no is substantially hindered anybody here, and it didn't. They got the warrant. They got the warrant. They got the blood. Saying no is not substantial hindrance. You can't be charged with obstruction for saying no. I mean, we've had several cases on obstruction where just by saying no doesn't get you to the substantial hindrance part. So on that question, I think that's easily answered, and it's been answered here with our precedent. Second of all, though, you bring up an interesting question that somehow the driver or the suspect that has been brought in is supposed to already know whether there's exigent circumstances. How are they supposed to know that? And by the way, if you looked at the DC-70, I mean, it's an exhibit in this case, it's in the record. The DC-70 that the officer reads to each, it's the form that the officer reads to each suspect or arrestee after they've been put in front of the breath test machine or before they're asked to take a blood draw. They read all the implied consent advisories. The question is back on the form: will you take a breath test? So they're asking for an answer. Well, his answer was no. And just by saying no to that's the crime. We can charge him with the crime when that's a search and they don't have a warrant at this point. They haven't shown him a warrant. I mean, how are they supposed to know that exigent circumstances exist? Well, if they do, then go do it. I mean, why even ask them? Why read them this whole thing? Just get your blood, get your test, get your result. So I don't understand how the what ifs and how we're supposed to take a totality of the circumstances or a case by case analysis on each one can justify it in one circumstance, but not in this circumstance. Every time somebody's asked the question, can I search your home, your body, your person? And they're given an option. And the Constitution guarantees that they can't be penalized for exercising that option. And we
Is
cited it.
is the implied consent valid for the driver's license portion of the proceeding?
Do I have to answer that? I'm sorry, Judge. It's just, I feel like I'm coming back here to this driver's license law, and we're not in driver's license law. And I don't mean to dodge your question in the sense, but here Derek Wilson's charged with a crime.
What I'm trying to get is the practical effect of what all these cases have been arguing this morning, but in particular this one, is that you're the one that brought it up, that they read the DC-70 and that they're required to do that in the process prior to administering a breath test or a blood test. They do that for several purposes, but one is to advise them of what the consequence of refusing the breath test is, that you'll be deprived of your license for depending on if this is a first, second, or third, and all that. What's the effect of that?
The effect of that is you have a potential to lose your driver's license. I mean, we gotten maybe too immersed with the two bodies of law. I mean, I know it's the same set of facts, but this court has constantly reminded us that they are separate bodies. It is a civil proceeding, like we were talking about in Martin. It's a civil proceeding when we're going through a driver's license revocation or suspension. And a criminal prosecution has a certain set of rules, and there are guarantees on that. And the substantive due process guarantees, and if the court finds that Judge Brown in Shawnee County was correct in the analysis, I'm a little confused as to whether it's a Fourth Amendment issue or a due process issue. I see both sides of that. But if they look at it as a substantive due process issue, it actually validates some of my concerns here that aren't even addressed. It's like this burden shifting that's happening. That now somebody that is suspected of DUI has to now prove himself that he's under the legal limit, or if he doesn't, he's going to be charged criminally. And that is something that totally contravenes our justice system. I mean, the presumption of innocence, that would be a substantive due process, right, that this crime violates. So, but my understanding was that breath testing, blood testing, it's all a search. And if you have a search, you have to have a warrant unless it falls under the exceptions, but they're per se unreasonable. And one of those exceptions could be consent. And just by saying, I'm not going to give you the consent, so you can't rely on consent to get your blood sample or your breath sample, just because you can't rely on that aspect of it, doesn't mean you can charge me criminally. Because I said, no, I won't give you that one. Find another one. Find another exception that will get there. That's the state's burden. That's the government's burden to prove their crime. But now, with this crime, the individual has that burden. Consent or else. You're going to be in trouble. And I know maybe that, and I think what you were asking is valid. I'm starting to see that. Didn't mean to like dismiss it as inconsequential, because the driver's license law is kind of how we got here. With the implied consent, when I've had clients who are like, well, yeah, I only took that breath test because they threatened me with the driver's license suspension. And we've had the precedent up there that said that, well, you didn't have a right to refuse in that sense. But that was in the context of a DUI prosecution, not in the context of how you answer a question to a request for search. And it was a request. And that's why the Fifth Amendment's triggered here. The Fifth Amendment's triggered because it is a request. And if you look back even further down on the statute, KSA 1001 on B, it's that the officer has to have the probable cause or the reasonable grounds to request. So it is a request, and therefore the answer to that request will be used against you in this crime. And because that answer is, they need to have Miranda. And since Miranda was never read, Mr. Wilson was denied his Fifth Amendment right as well. And the district court got that correct. And do we have any, are there any questions about the Fifth Amendment? Because I maybe simplified it, but is there something I'm missing about Fifth Amendment that?
Just on your last point, I mean, Miranda's distinct from Fifth Amendment voluntariness, isn't it?
It is.
So does that have any impact on your argument? I mean, you said that because you don't get Miranda, the Fifth Amendment was violated. I'm not sure that's exactly right.
Well,
Miranda was violated.
If Miranda is
It can result.
it was a judicial creation by the United States Supreme Court to make sure that the whatever statement was made following a custodial question was voluntary. So I think it all is
It does multiple things.
It
And also
does.
informs people of their
Right,
right to
and-
counsel and their right
True.
to kind of questioning and their right, yeah.
But in this context, it's the same thing about whether or not you can give an answer. And if somebody does give an answer to the question, will you take a breath test? Deputy Soares asked Mr. Wilson, will you take a breath test? No. All right, well, now I'm going to charge you with a crime, even though you weren't protected. So ultimately, it wasn't a voluntary answer. He only answered it because he was in handcuffs and he was forced to after he read him the implied consent. So it would be the only way he could do it. I guess technically you'd say remain silent, which would then also be construed as a refusal. And now he's back where we came from. The fact that he exercised the right to remain silent, even though he wasn't advised to, he exercised it. And did I answer your question, Justice?
Yes.
Okay.
Thanks.
Because and we go back to the conditions, and a lot of the earlier counsel made up or raised a lot of issues, a lot of questions I have with the implied consent law and how it really steps on people's constitutional rights in the context of a criminal prosecution. Okay, because I know I have questions in the civil arena, but we're not hearing that. But here we're talking about in a criminal prosecution, and the implied consent law steps on it in several different ways, but in this regard, it tells you that you can be charged criminally if you don't say yes. And so it's conditioned. Your response to the question of whether you take that breath test is conditioned. It's not just an open question. Yes, or it's not a yes or no. It's you're going to get that. You're going to have consequences depending on that answer. So, and at that point in time, what they're asking to do is to do a search, a Fourth Amendment search, to search the body, and that's the question you're answering. I see my time is up. Is there any further questions?
Any more questions? I see none. Thank you, counsel.
Thank you.
You reserve 2 minutes for rebuttal.
Sorry, I left that up here. I guess just the one last point I'd like to end on is taking the Fourth Amendment out of this, because there is absolutely a constitutional right not to be tested unless there is an exception to the warrant requirement or a warrant. But where is there a constitutional right to refuse the testing? Which is what I think the judge held here, that there were other constitutional rights implicated by refusing testing, and we disagree with that conclusion, and we would ask that this court finds it constitutional under the Fifth Amendment due process and unconstitutional conditions. Yes, Your Honor.
Mr. Wilson was held down and they withdrew blood involuntarily and it tested 0.18. Is that correct?
They did do a blood draw, yes, after the warrant.
Okay,
I
but
don't know the number,
it
Your
tested
Honor.
over the limit.
Yes.
It tested over the limit. So, my question is if they had gotten the warrant and forced the blood draw and it had come up, 0.01, or 0.00, would you still have a valid constitutional, conviction for having said no? Having refused?
Yes, I think so.
And why wouldn't he have had the right to demand his Fourth Amendment rights, that there be a warrant?
Well, there was a warrant, so there was
Well,
not.
I know, but he's prosecuted for saying no before the warrant was obtained, wasn't he?
Correct.
And so why couldn't he legally say, no, I want you to get a warrant because you have no reason to do this. I don't have blood in my system.
Alcohol.
Or,
You're
yeah,
truly a medical marvel.
yeah, I don't have alcohol in my blood.
I think it goes back to the legislature can, under the implied consent law, when you sign up to get a driver's license, like we've said many times, you're consenting under the implied consent law. And there's no constitutional right that can take away the legislature from punishing that refusal. I don't think they go hand in hand. I think they can be completely separate. And he got his Fourth Amendment right was protected because there was a search here, but he still can be prosecuted for that refusal because there's nothing constitutionally that stops the legislature from making that a crime. Because what the purpose is to compel someone to do the testing. So in further, I'm not sure what the right word is, but in furtherance of that, coercing someone, which this court has held that that's constitutional, you can coerce them under the implied consent. Criminalizing it, taking it a step further, it's a separate issue that doesn't involve any other constitutional rights. I don't know if that answered your question at all, or if I'm just mumbling, but
It's reneging on the consent you gave to get your driver's license. We've criminalized reneging on the consent you gave us before we gave you the license, and now we can throw you in jail.
Yes, because we're trying to compel you to do the testing you already consented to. And again, these criminalizing of refusals, it's not a first refusal. You have to have at least one prior, so it's not. Again, we're narrowly tailoring it to people who have already done this before. It's
So,
repetitive.
as a
Invoke their
follow-up
constitutional rights.
to Justice Biles' question, if that is the case, if the state's criminalizing a person for reneging on their granting of consent, why shouldn't the sanction be limited to the state pulling out of its part of the bargain, which is giving you a license? Why shouldn't that be the limited sanction? Why should the state be allowed to sanction that, what we describe as reneging, even further than
Even
that?
further. I was trying to think of an answer to that when you asked it earlier, because there's no constitutional right that they're giving. The criminalizing of the statute, you don't have a right to refuse it, a constitutional right to refuse it. So there's nothing limiting the legislature from criminalizing it. And the legislature is doing that to further the remedial purpose of the law for the public safety.
It's kind of like, we're going to make a bargain with you, and if you break it, not only will we not be obligated under the bargain, but we're also going to charge you with a crime.
Correct. We're going to continue to compel you to consent.
Could we make it a crime to breach a contract with the state to build a building? Or are we limited to contract remedies?
I don't know. I would say you're limited to
Seems to me it's
contract
kind of
remedy.
the same question.
Well, yeah, I understand. It's still not your right to drive, though. It's a privilege. I guess maybe it's going back to all that. We're giving you the privilege so we can condition it on.
And what
It's on
they're
equal
suggesting
bargaining.
is the privilege can be removed. And
Correct.
that would be the limit of the contract remedy. That
And
you
why
get
go
to not
further?
perform because this person is not performing their side of the bargain.
Rescission.
I
of
see
the
what you're saying.
contract.
Right.
I don't know if I have a good answer for that, Your Honor.
I think there was a suggestion of unequal bargaining power in somebody's question.
Yeah,
How badly do you want this license and what are you willing to give up for it?
right.
But you say it's okay.
Yes,
Any further questions? Thank you, counsel.
thank you.
Thank you both for your arguments this morning and this afternoon. Court will take this matter under advisement. That concludes this morning's